So we'll get started in just a second, but to preface, I think this last session is going to be a little bit more interactive. Hopefully it can open up to some conversation. We'll do a shorter presentation, but then I would love to see a little discussion, especially I know there are some folks who have experience taking cases in the crowd, and I would love to have them share their wisdom, their experiences, and the things that they've learned either through experience or the hard way, things that I should have told them or warned them about that they didn't know about going in, whatever it might be. This presentation, we're going to be focusing on just what it's like to take a case. So if I can, just a show of hands, I can identify a couple of you who have taken cases, but can you raise your hand if you're an attorney? Perfect. And if you have taken a case at the detention center? All right, so we got three folks, yeah, and so and McKenna, you've taken one too, so you've been in there, so yeah, so as y'all have your experiences and observations, feel free to raise your hands. I'd love to hear your all's thoughts as well as we go through this, because clearly the process.
I can run Mike.
Oh, perfect. Yeah. Clearly the process of learning is something where, sometimes I think it's easy for me or Jesse, who have done a bunch of cases, to take for granted certain steps. So I would love to hear your feedback. But to get started, basically what we want to cover is, we've talked quite a bit about the Northwest Detention Center already. So I'm going to go through that fairly quickly, but again, since we're taping this for training resources, I'm going to go through it. And then we'll go over what you should be doing to get started on your first case, the nuts and bolts of removal defense. Jesse touched on it, so I apologize for a little redundancy. And then we're going to go over what you're responsible for and what's expected of pro bono counsel, and just tips, best practices, and conversation about that. So to get started, if you're going to take a detained case, you need to know where to go. The detention center, the ICE processing center, is 1623 East J Street over in the Tide Flats. If you need to contact them for any reason, the phone number is right there in the slide too. It's press 6 is the shortcut, and then just ask to go to the front desk. Generally, if you call that line, spoiler alert, they're not going to be very helpful, but you may be able to call, and if you call and you get a front desk guard who's pretty nice or whatever, you could say, I'm driving to the detention center right now, I'll be there in 15 minutes. Can you call my client? His A number is 12345, and they may do that. It might save you a little time. At least right now, the guards in the late afternoons and evenings tend to be a little friendlier than the morning crew, my personal opinion. So the detention center here in Tacoma is the main place where clients are going to be located. If you take a case, your client is most likely going to be in Tacoma for the duration of their case. But there are other places in the region where folks get detained by ICE. One of them is the Federal Detention Center in SeaTac. We have had some clients who we refer to pro bonos from that detention center, especially, 2 summers ago when family separation was a big thing, and a lot of parents who were separated from their kids were brought up here, and they were held in SeaTac, and we needed to get pro bonos in there to do intakes, to do referrals, to do bond hearings, and then eventually a lot of those folks got moved down here to Tacoma for their individual hearings and their merits. Another place that Jesse referenced earlier is Northern Oregon Regional Correction Facility, NORCOR. Generally, ICE will subcontract some bed space. When the detention center here is really full, they'll subcontract bed space, send people down to Oregon. Very shortly, it can be a massive headache if you're trying to represent that person, because you never know if your client's going to be in the Dalles, Oregon, or if they're going to be in Tacoma, and when you'll be able to visit them. So if you have a client who gets moved, we have kind of some back channel people in Oregon you can try and contact to try and pressure them to send your client up for visitation. There is an obligation for them to transport your client up to Tacoma if you're representing them here, so that you have access to your client, but it can come up where it can be a big headache. That's the place right there, so you'll soon get to know it if you take a case. And just a couple photos from the inside. We're talking about the pods earlier, and this is just a photograph from inside. Basically just bunks all around. Every detainee has a small little foot locker that they can use. There's like picnic tables in the middle. And to your question, it looks like there's 3 phones right there. So hopefully there's less than 75 people in that room. But yeah, that's basically the setup. There's some TVs in there. Another challenge that I've heard people complain about, pretty surprisingly at the detention center, is disagreements in the pod over what channels the TV should be on. And I've had more than one client put in solitary confinement over a disagreement of that. Again, the people who work at the detention center, the main characters and actors you are going to interact with are the Executive Office for Immigration Review. That's the immigration court. It's going to be the judges, it's going to be the clerks, and they're all housed under the Department of Justice. So as you go into the detention center, the court section, once you go back there, that's Department of Justice territory and their employees. There's also ICE, and they're part of the Department of Homeland Security, as we were talking about the different departments earlier. And then the folks who you're going to interact with the most face-to-face will be employees of the GEO Group, which is a private corporation. They're not government employees, but they are the ones who manage the prison facilities. So when you walk in the morning and you go ask to visit your client, the person who you'll talk to at the front desk is going to have a little GEO badge on their shirt. They're not a government employee, but they're kind of the gatekeepers. And then when you go in the back and you're waiting in the attorney visitation room, the guard you'll speak to there is also going to be a GEO employee. So you'll see them more than you'll really get to see anyone else, because the government folks lurk in the shadows a little bit. A lot of that's going to be written correspondence, telephonic correspondence leading up to the hearing. But with the GEO folks, in general, who applies for that job? Largely, it's retired vets and people who have past military service. In general, I would say that the more you can be respectful and try to keep pleasant interactions with them, even if they can be frustrating to you or off-putting to you, it's a good investment in moving through the system efficiently. But definitely, there have been times where I've failed at that, to be honest. So with the Executive Office for Immigration Review, a couple of things you need to know. If you're going to represent someone in immigration court, you need to become the attorney of record before the Executive Office for Immigration Review. And to kind of warn you, there's a lot of acronyms in immigration law, and so EOIR is something that will come up a lot. And if you see that, you can basically realize we're talking about the immigration court. And so if you're going to enter an appearance with EOIR, you do that, it's a 2-step process. For the very first case you take, you need to go online to register yourself as a valid attorney or accredited representative qualified to take a case. So once you have done that and you register, you get what's called an e-registry number. And that will be a number that you have to write down on any entry of appearance you issue for any client. So for the 3 of y'all who have taken cases previously, you already have that ID number. You just write the same one down for every case. It's never going to change. For individuals who are taking a new case for the first time, you will need to go through that process before you can take a case. And there's no reason you couldn't do it now, even though you don't have a case. Once you're registered, you remain registered as long as you're barred as an attorney.
Unless they have the wrong address.
Yes, so changing your address and making sure that it's updated is important. As has been learned the hard way in the past, if you change addresses and don't notify immigration through that e-registry portal, it can turn into a headache where they will consistently mail you documents at the wrong address until you fix that. No matter how many times you go to the court and try and politely explain what your real address is, it has to happen in the portal or else it won't get updated elsewhere in the system. And then in terms of your interaction with the immigration court, you can't really do much without an E-28 on file. But once you have filed that and you have entered your appearance as the attorney of record, you have certain things that you can do. Like one of the very helpful things you can do right from the start is you can make an appointment to review the A file or the official court file for your client. So basically just go up and with a file D28 politely ask the clerk if you can schedule an appointment. And they've actually been really good about this lately, trying to schedule the same day when you come in and ask to see the file. They'll pull the file, set up a little room for you off to the side, and you can spend as much time as you want going through the file, figuring out what the government has filed against your client, if your client filed an asylum application before you got on the case, what did your client write in that application, what else is in there, so you know exactly what the judge will be looking at on the day of court. Also, when you're of record, you can submit evidence, motions on behalf of your client, but an E28 doesn't give you permission to correspond with ICE. So if you want to talk to your client's deportation officer, or you want to talk to the trial attorney who's the opposing counsel on the case, you would need a different type of relief, or a different type of entrance for appearance for that. Also, EOIR includes the Board of Immigration Appeals. So if your client loses their case and you choose to continue fighting and represent them on an appeal, that would also be in front of the same agency. And then in terms of ICE, there are two main roles that they provide at the detention center. One are the deportation officers, who are more the enforcement arm of things. They're not attorneys by and large. They're active in the arrest and the detention of the immigrants populated at the DC. And there's also the Office of Chief Counsel, and this is where the acronyms get really screwy. So the people who are the prosecutors in an immigration hearing, their formal title is the Office of Chief Counsel. They will also be called trial attorneys, prosecutors, ICE, OCC, TAs. It's a bunch of word salad, and I apologize, but I will probably call them multiple things in a phone conversation with you and confuse you. Basically, if you need to correspond with either the deportation officer in your case or with the opposing counsel for any reason, you need to have a special Department of Homeland Security notice of appearance, which is a form G28. So G28 instead of E28. And your client does need to sign that. So one thing that we'll talk about in terms of best practices is get a G28 signed from your client right away. You don't need to file it right away, but it's good to have it on hand so that if you do need to reach out urgently to a deportation officer for any reason, you do have your client's consent to reach out. Another thing that is helpful if you're going to try and correspond with ICE, there is a duty attorney line. So if you need to talk to opposing counsel, there should be someone in that office that's on call at any given time during business hours to receive and answer your phone calls. So if you have a question about a filing, evidence, anything like that, you can try and call the duty attorney line and see if you can iron it out. Certain trial attorneys are easier to deal with than others, so sometimes you're lucky, sometimes you may not be. But the other thing that ICE can handle, deportation officers have sole discretion in parole requests. So if your client is one of the ones who is not fortunate enough to be eligible for bond, you can try and reach out to the deportation officer to propose that your client be released on parole if there's a compelling argument. These are not granted that often, but if you think your client might have a valid request for parole, give me a call and I'm more than happy to talk about it. In terms of GEO, I just talked about this a little bit, but they're the guards in the front desk. They don't really have any access to any immigration information, so you won't be able to get it from them. But they would, so the one other important thing, the only real information they get from ICE that they will use is the client's A number, which anyone who's at the detention center is assigned an ID number like at any other prison. And the ID number corresponds to the same file identification number that ICE and the court will use. So, talking about your first case, the first thing you're going to do when you take a case is you're going to wind up talking to me, and we will go over a case referral form that's going to have the general details and usually a 2-page rundown of your client's case. It's going to be broad strokes and give you a rough idea of what you're dealing with, where the client's from, what type of relief we think is most viable for that person, asylum, cancellation of removal, whatever it might be, where, if it's an asylum case, we believe the nexus is this, and this is why we believe it's that. This is the evidence that we think could be obtained, and try to give you an idea of what will need to be accomplished so that everything that Jesse talked about in the presentation about asylum, you have an idea of where you're going. Again, it's helpful when you talk to your client to realize that this stuff might evolve. There's some things that, in one intake with our office may not come up, but then your client will build a rapport with you, begin to trust you, and they might tell you something that I never knew. And that's totally fine, but for that reason, I think it's good to have a sense of how the asylum law works so that as you get that new information, maybe there's a different argument that you can make that there's persecution for political opinion, but also a particular social group or some other type of relief that may appear stronger or potentially weaker than we initially thought. So as you review that and then get to know your client, it will kind of develop. But before you go to see your client, I think it's a good idea to go through that, identify what you're going to try and accomplish in that first meeting. What do you want to talk about? What information do you need from your client based on what's in that referral? What questions are unanswered? Where do I want to go from here? A really important thing to do, I will send you an attorney acknowledgement form when you begin a case, and it's really critical that you sign that and return it to me. If I don't have that in my hand, you are not covered under NWIRP's malpractice policy. So there could be a liability issue on your end, and it's in everybody's best interest if I have that form to show that you've committed to taking the case, and then I can, have you covered on that malpractice. And then the final thing that I think is a good idea to have when you go in to have the client, you don't want to walk in and talk to your client and have no idea what you're going to be talking about or doing. It's good to come up with a sense of a work plan, know what you're going to need to accomplish. What language does your client speak? Are you confident that you speak that language well enough to communicate with them? Are you going to need an interpreter? Have an idea of when you're going to visit your client. And especially like if you're working with an interpreter, which I know, Jason, you've worked with an interpreter there in the past, I know at least. Matt, have you? Yeah. It can be challenging because you're trying to coordinate your schedule and an interpreter's schedule to get to the detention center. So having an idea of what works is going to go a long way in advance. Like maybe you figure out Fridays work really well for all of us, so we're going to try and make Friday the visitation day or something like that. But having an idea of that is helpful for the interpreter, but also for the client to be able to explain what to expect. They're sitting there in the detention center can be really isolating, and having an idea of when their attorney will show up to see them and that kind of accountability to your client is, I think, just really, really helpful in developing trust. And then I think the other thing as you're getting ready to take a case, most pro bonos report spending, usually between 40 to 70 hours, 45 to 65 on a case, just based on what I see in the reports. So make sure that you're eligible or that you think that you can commit to that time investment at the beginning of the case and just have a realistic idea of what it'll take. Does that time estimate seem reasonable? I mean, I know you go way over that, Paula, but that's great. We love that. And then in terms of visitation, I think this is an important thing to strategize too. Visitation hours are from 7:30 a.m. to 10 p.m. And there are 7 visitation rooms. So there's a shortage of space, and there's a lot of attorneys who are making their money taking detained cases. So you'll find that during business hours, it can get pretty crowded in there. I mean, of y'all, how many of you have waited over an hour to see your client? Probably, yeah. Mm-hmm. Yeah. So truthfully, like the worst possible times to go are at 10 and around 4:15, 4:20 in the afternoon. During those times, the detention center stops all detainee movement so that they can do a head count. So I would really avoid those times because no one's moving for at least an hour. So you're not, if you show up at 9:55, it's likely you're not going to see your client until at least like 11:15. But mostly what I advise people, what my preference is go in the evening, like swing by around 5:30 in the afternoon after work, go on a weekend. If that works for you and your schedule, it can be really helpful. Just because you're not going to wait in line. You're not going to lose a lot of time just sitting there at the detention center. But also anticipate that you're going to be waiting for a little bit. It's helpful to, bring a laptop or bring some kind of work or something to read through. Research country conditions on your client's home country while you're waiting. In terms of general things to make sure you bring, a photo ID and a bar card are requirements to get into the detention center. The bar card thing, they've been stingy about it and then they haven't been. If you don't have a bar card printed out, like if you're barred in New York State or a state where they don't give you a card, some proof that you're in good standing should be sufficient, or generally a business card will get by for a lot of folks as well. You can bring laptops and cell phones to the detention center. That's not an issue. Food and drinks are prohibited, so no snacks, and definitely no sharing snacks with your client or anything like that unless you want to get them in trouble. And there is a dress code at the detention center, so, no, I don't even know what's on it. Like, you have to have your shoulders covered. Yeah, it's a pretty sexist thing, I'm not gonna lie. But the other thing, it does get chilly there sometimes. Jackets are allowed for attorneys or blazers or something like that, so that shouldn't be an issue. But yeah, expect delays, be patient. It sucks to be waiting at the detention center for a long time, but it sucks more for your client to be detained. You have a question?
Yes.
I'm sorry.
Sorry, real quick. No appointments, you have to just go and wait.
Yeah.
And the 55-hour average that you said most people
Mm-hmm.
spend, that does not include that's not visitation time. Is that the bulk of that is not visitation time, the bulk of that's extra?
Well, the intent of the question on the little questionnaire I send out at the end of the case is how much time you spend working on the case. So the time you're waiting at the detention center isn't counted. But some attorneys might report it differently. I'm not sure.
I just meant to figure out how many visitations would you recommend? I would actually love to open that question up to everybody to see if people have a thought. I think it really depends on the client and the case. I think there are some cases that are very straightforward and the client is coherent and put together and have no problem being honest about what happened to them with you from day one. There are some clients who I think you're going to have to build trust with and they're going to have to feel comfortable with you. There are some clients who I think are going to want to talk to you about something that has nothing to do with their case, and they're going to be very insistent that you need to know about the way things work in my country, and these are the people who are important. It's like, no, that's not what we need to talk about. This is not an element of your case, and it's not really relevant, but clearly it's important to you. So depending on how you steer back and forth with your client, it varies. There are cases that I've had that I feel like come together very, very quickly and easily, and some where you have a client who's going to be more challenging and it'll take more time. So I think you'll get a sense as you start working with your client. But I would say that the bare minimum would be 5 to 7 visits, like baseline bare minimum. Trying to see your client, every other week at least to prepare a case. Some cases might, if you are really putting time in a session, it could be less than that. But I would encourage you to try and see your client at least 5 times.
And just breaking it down by sort of the elements that you would need to present your case before the court. I think first, obviously, is just meeting the client, building rapport, signing the retainer, and then usually we have pro bono submit declarations, and that can take 2 to 3 visits. Again, depending on the individual. I've had it take only a few, and I've had it take 7. So it really depends on the client. But then the next step in that would be preparation of testimony. And again, there's no great answer for how many times you should go into prep. Oftentimes with clients, there is the risk of over-preparing them and making the testimony sound pretty rehearsed, and that's not good. I've also had clients who, the first time we do it, it's great, and then the more we practice, the worse it gets. So I think it just depends. But definitely, I think 7 is kind of the minimum in my mind.
Do they kick you out after an hour or something?
No, you can stay as long as you want. I mean, I think that that's something to acknowledge too, that like it's, yeah,
I don't want to stay in those rooms for
Yeah.
longer than
Yeah.
an hour.
They'll kick you out at 10 p.m., but really, like, that would be the only time, and I mean, yeah.
yeah. I mean, I think that it is really important to acknowledge how draining it is, though, because I've, tried to go on marathon, like I'm going to see all my clients and I'm going to be here from 1 o'clock until 7 o'clock in the afternoon. And it's really, I mean, again, more difficult for our clients who are actually detained, but it can be really emotionally draining and just physically draining as well.
Yeah. I don't know if any of you guys have anything to add from your experiences or about visits or how often to see a client?
No paper clips.
Oh, yes.
Do not leave them any paper clips.
Paper clips can be contraband. Basically, the best way to deliver any documents would be stapled or loose in an envelope, just because otherwise things can get taken away from your clients. Yeah.
Yeah, I'd say the staff are pretty, compared to Pierce County Jail, pretty chill, pretty receptive to professional visitors. It did take a little while waiting to get in. I didn't have to wait an hour, but I could bring a laptop, which you can't do at Pierce County Jail. And I was given all sorts of latitude as far as time with my clients. So the rooms are a bit chilly, I would say.
Mm-hmm.
But I thought visitation was kind of a good thing as far as how easy it was to be able to work in the facility. So I didn't have a problem. And as far as times, I had to go after work, 5:30 or 6. It seemed to be relatively easy to get in at that time. So that makes it fun.
Yeah, evenings are really, I think, the best time to go. It's when I prefer to go when I do. Generally, I think the afternoons, we were talking about the LOP program that NWIRP provides where we go in and do one-on-one meetings with, pro se individual after pro se individual, and we're there until we're done. And that goes from like basically 1 p.m. until it's finished. So you can count on, the middle of the afternoon, 3 rooms are going to be booked up by NWIRP attorneys. So then you only have 4 rooms that you're fighting on with other attorneys. So afternoons are probably the stickiest time. And then the other thing that, and I screw this up pretty much every time I try to go to the detention center on a weekend, remember that count still applies on the weekend, and don't just sleep in a little bit and then roll over at like 10, and even though there's nobody there, it's still count, and you're not going to see your client. So I think those are all good tips.
And there is Wi-Fi?
There is not Wi-Fi.
Oh, so you can't really work on some things there.
No, yeah, you can do like Word documents if you're preparing a declaration. I think different people have different preferences. Like for me, I prefer writing out a notepad so I can kind of take notes shorthand style and then I'll type it up later. A lot of folks will go in with a computer and type their declaration with their client.
Will you voice record your conversation?
They will, and generally, like you're also allowed to use a telephone to call an interpreter or something like that. You're not allowed to use a telephone to make personal calls or anything like that, and if they overhear something like that, they'll make you put your phone away. But I've definitely just set my cell phone on the table with like the record thing going and recorded the conversation. And I think recording or, like taking notes by paper instead of a laptop, it's helpful because you're making more eye contact with your client. You're making sure that they're being seen. You're not hiding behind a screen.
I didn't know if that would put them on edge, that they're being recorded or something.
It's a judgment call. I think I would ask your client's permission, obviously, before you start recording, but I think different clients will be comfortable with different things depending on their past experiences, and I don't think there's a hard, fast answer.
Don't bank on cell phones working, though.
Yeah.
So
Reception can be pretty awful. But yeah. Oh yeah, the lobby is even worse, yeah. Mm-hmm. All right. But we'll keep going, try and get through these slides, and then we'll have more of a loose conversation. But the first time you meet with your client, I think a big priority, when we refer a case, we go and we tell the client, look, we have placed your case with this attorney, and we're going to move forward. You have a lawyer. Hooray, good job. Go you. And so it's really helpful that if you're not going to be able to see your client within at least a week or so, a minimum of 10 days by the time that we refer the case formally to you and you sign the attorney acknowledgement, let us know so we can set your client's expectation accordingly. Like, you're gonna look like, I mean, it's gonna color your initial interaction with your client if you don't show up for 3 weeks or something like that. So I think it's really important to remember that as you're building a relationship and getting trust from your client, try to be prompt in those things and make sure that you are following up and treating your client with that courtesy and professionalism. Also, I think it's a really good idea to bring documents for your client to review and sign at the first meeting. We'll give you a template of a contract, a client service agreement for you to go over with your client. I recommend printing 2 copies of that so that your client can sign both, keep a copy for their own records, but then also you'll have one for your file. And I think it's a great idea to get a G28 signed by your client in case you need to contact ICE at some point in the future. Also at that first meeting, hopefully your client will come down with some paperwork. They'll be told it's an attorney visit, so hopefully they'll grab whatever they have and bring it down. It's a good idea to look over what your client has. Documents to look out for, I think, are a credible fear interview and what's called a record of deportable or inadmissible alien. It'll say in the corner form I-213, and that's basically the ICE arrest report where they justify why they detained your client. You want to look at those documents and get that information. Usually I'll ask my client if they will give me permission to take those documents back to my office to make copies, and then I will return them at my next visit. Or you can download apps that will let you take a picture on your phone and it'll convert it to a PDF so you can email it to yourself. So one of those things, but it's good to have those documents for your file ASAP. Another thing that's just really minor about the detention center, but it's incredibly frustrating when you're getting started. When your client files their asylum application, which they likely have done when you take their case, they'll be given a notice of hearing for their final case. And on that notice, it will specify that they either have to turn in all evidence 10 days prior to their hearing or 15 days. If there is a pattern for why they decide 10 or 15 days, I haven't figured it out. It seems pretty incredibly arbitrary, but it's a really important thing for you to know because you need to know when your evidence is due. Like, do I have to file everything on the 17th or the 12th? It can be a pretty big difference. So try to check the notice of hearing as quickly as you can and calendar when your evidence will be due. If that date that's 10 days prior to the hearing or 15 days prior to the hearing falls on a weekend, it will be the following Monday. If the Monday's a holiday, it'll be that Tuesday. And then the other thing that I think is great to review with your client at that first meeting, is there anybody on the outside who you can contact, like a family member via WhatsApp or someone who lives they have, an uncle that lives in Maryland who might be able to help or something like that. So you have someone who you can reach out to who can help you to get that corroborating evidence. Your client might have that phone number or information that we don't have. So it's helpful to kind of interview with your client and figure out, who's on my team? Who can I reach out to help me build this case up so it's not just you and your client? And then I think the other thing is have a discussion about how the case is going to work. Your client may have never had an attorney before. Your client has almost certainly never been in immigration detention applying for asylum before. So they should have an idea of what to expect, and you should be able to paint a picture of what you're going to do. And I think it's better to not overpromise, but make sure that whatever you're telling your client to expect from you is something that you can commit to doing and that you can keep your word on it. And then it's great to give your client a way to contact you, or if you don't speak the same language as your client, if the volunteer interpreter is willing to give the client their phone number so that the client can contact them. It's great if your client can have a way to contact you, but if there's no way, because you're relying on a telephonic interpreter or you don't feel comfortable giving out your phone number or anything, I think it's all the more important that you really commit. If you say, I'm going to visit you next week, that you do everything in your power to visit next week. Support staff, interpreters, experts, there are a lot of people who you might want to come to the detention center with you, but if someone is not an attorney, they will need to get cleared from ICE before they can go to the detention center. So the instructions are here on the slide, which I'll share with you, so I won't go through it all, but basically you email ICE at that address, and you specify, the information, date of birth, social security number of the visitor, and what the visit's about and how long it will last. So if you have a psychologist who's going to do an evaluation of your client on this date, you can just say they're going to be here from this date from 9 until noon. If you're going to have, a paralegal or an interpreter or somebody who's going to be going with you every single time, you would just say, this person's going to be working with me and helping me in preparing the case as an interpreter, as a paralegal, whatever, and they will need clearance for the next, generally they'll extend it as long as 9 months, so I just ask for clearance for 9 months just in case. And they'll usually approve those requests. But you need to get that clearance or else ICE won't put you on the list for GEO. And like I said, GEO will just, if you're not on the list, they don't care. So you need to make sure you get cleared by ICE. Otherwise, GEO, they have the keys and they won't let you in.
So one point on that with the medical and psychologist evaluators that we're having come into the facility, I would err on the side of just having them cleared for multiple visits, just because oftentimes it can take multiple visits to actually accomplish all that they need to do. Oftentimes the psychological evaluations are very lengthy, and if they need an interpreter, it might take a while. And we're finding that when we do request, if we specify a date and time, as important as it is, they often will not extend it any more than that, and then they're set in a situation where we have to ask every time. So err on the side of just asking for 6 to 9 months, regardless of what's going on.
That's good, yeah. And then if you can't find an in-person interpreter, obviously that's preferable for many, many reasons, but we can also work with you to set up telephonic interpretation services. So if you're having a hard time finding an interpreter, if I'm having a hard time finding an interpreter to work with you, we'll talk about that and kind of come up with a game plan. But even in a situation where, and I know this has happened with at least 1 or 2 pro bonos recently, where they had a volunteer interpreter who was going with them to every meeting, but then they needed to see their client that Tuesday and the interpreter wasn't free. Let me know. I can give you a number you can dial in on for remote interpreter service, and we'll talk about that process if it comes up. If you're doing a medical evaluation, I think there's different special considerations. They have to be in a special area. You can't, clothing can't be removed. Photographs are limited. You have to get special permission for what's going to happen. So if you feel like it's helpful to have a medical evaluation of your client, let's talk about it and kind of go over what to do with that request, and we'll kind of handle it on a case-by-case basis. If there's a lot of other corroborating evidence, if your case is really strong, like a country where the country conditions are just extremely compelling, like Cameroon or Venezuela or Cuba or something like that, it might be superfluous to do it, and it might be a bad use of resources when there are other cases that would benefit from that expert more. But we'll kind of explore and talk about that as it comes up. And then once you have met your client and done the initial meeting, the next steps moving forward, enter your appearance early in the case, and that way if anything happens, you will know. Also, I think the court is very motivated to not have any gaps in their court schedule and be very efficient with cases. If you're not on record on a case, you haven't filed your E28 yet, if a judge has a vacancy, they might just change your client's court date without consideration for your schedule because they don't know that you're on record. So the earlier you can file your E28, the better, the more control you'll have over your client's hearing date. You can either file it electronically or in person, but it's a good idea to do that. And again, very important, this is kind of common sense, I think, but meet your client before you file the E28. Make sure your client likes you and wants to work with you and hasn't hired another attorney already that we didn't know about. It's a really good idea to get your client's consent before you jump in to represent them, because it's just basic courtesy, I think, because clearly your client should be able to say, no, I don't want you to represent me if they do feel that way, and otherwise it presents like we're not giving them that choice or that autonomy. You might consider making an appointment to review the court file, especially if your client filed their asylum application and didn't keep a copy for themselves and you have no idea what they said in there. You want to try and go look at it if it seems necessary or helpful. And then one thing that we'll talk about as you're working on a case is kind of coming up with a plan for what you'll need to do to prepare your case. kind of sketching out a casework plan or something like that, especially if it's your first case, to identify what are the deadlines, what's the strategy, what do I need to be working on. And so kind of make sure you have that game plan and you know what you want to be working on, and then be in touch with me. I'm more than happy to be helpful with any technical support questions, anything like that as you're trying to think your case out. Some important resources, and again, I'll share these slides, but the Immigration Court Practice Manual has all of the rules for the courts, the filing instructions, so you know how something should be filed, double hole punched at the top, needs to be paginated. If you're filing a motion, it has to have a proposed order in the back of it. It'll give you all of that and more information. So it's good to look that up. I mean, you can just download it really quickly online and look through the manual to understand what's in there. And then Jesse alluded earlier to the Ninth Circuit Immigration Outline. It's a really fantastically good resource that everything should be that easy, but it's a great way to research case law. Again, if you have questions about procedural stuff, case law stuff, these are ways to look it up yourself. But remember, you're not alone either. You can talk to me about it and kind of brainstorm things, and I'm happy to suggest templates for preparing things and different case law that might be relevant to your case as it proves useful. So we'll kind of go over the very basics of a case real quick. Again, this is one of those flow charts where it's hard to read everything, but basically the process is going to be you get detained for a client, the process would be you get detained, ICE issues a document called a notice to appear. That's a charge saying, hey, we're going to try and deport you and this is why. After that, a few weeks later, you'll be scheduled for an initial hearing called a master calendar hearing. At that application, and you may go to have either of you all gone to a master? You had a master for your Russian case, right? Yep. Mm-hmm. Yeah, so if you get on a case early enough, you might be able to go to the master calendar hearing, present the application with your client, and do pleadings and all of that. The vast majority of the cases that we place with pro bonos have already had their master. They've already filed their application for relief. So you're going to kind of skip that step. And it will be the process in between the master and the individual hearing, the ICH, where basically the client and you will be working to prepare the case for that hearing. At the individual hearing, which, like we talked about, would be probably 90 minutes or 2 hours. It might be the entire afternoon, but usually only a shorter period. The judge will evaluate the case, hear witnesses, all of that, and then maybe you win your case and your client gets out. Maybe you lose your case and your client gets ordered removed. Either way, there is a right to reserve appeal. So your client could conceivably win their case, and opposing counsel for the government could opt to appeal the judge's approval of the case, in which case your client remains in detention until the appeal is resolved. Similarly, if your client loses the case and they want to appeal, they also have the right to appeal the decision. If there is an appeal, it goes to the Board of Immigration Appeals, which is also EOIR. It's in Falls Church, Virginia, which is, they handle all nationwide appeal cases. If the Board of Immigration Appeals dismisses the appeal, then you have the right to appeal to the Ninth Circuit and continue fighting it, and that could take years. Typically, we wouldn't advise pro bono counsel to take a case all the way up to the Ninth Circuit unless they had quite a bit of immigration experience. We would talk about it, and if we felt like there was a really good argument to fight the case at the Ninth Circuit, we might invite a pro bono counsel to co-counsel with a NWIRP attorney or something of that nature. But generally, it's unlikely that cases progress that far because there aren't that many clients who are willing to spend years in detention fighting. So the notice to appear is one of the chief documents that you'll look at in the file. This is what the client will get at the initial master calendar hearing, or it might be issued before then. It would be issued when an affirmative application is denied or when the person is apprehended by ICE. And it's a good idea to look over the NTA with your client when you first take the case. Make sure everything's correct. You know, that it says your client's from a citizen of the correct country. A lot of times we'll see issues where, maybe that person was born in Sudan before the North and the South seceded from one another, and so it says you're a citizen of Sudan when you're actually a citizen of South Sudan, or there might be an error in there. The date of entry, that could be incorrect, and that could, with the 1-year deadline and other things, that could have severe implications on your client's case. I had a client where it seemed like it was just a simple typo where someone misread someone else's handwriting, and the NTA said that my client had entered in 2011 instead of 2017. And because of that, it was important to try and correct it on the record, because at that point it was 2017 and it would have affected my client's eligibility for asylum. You review all of that, and if there's any issues, just give me a call and we'll talk about it. Generally, this isn't a big concern, but it's definitely important to review with your client. And here is a little template of an NTA to see what it looks like. And obviously it's hard to read from over here, but it gives you a sense of what the document is, and then you'll see the slide. And so at the master calendar hearing, if the client's represented, they'll appear with an attorney. The attorney will enter their appearance at the master. You'll go over the allegations of removal and admit them or deny them if there's a reason to deny them. You'll request a certain form of relief, asylum, and then the government will present evidence that may already be in the client's possession. If not, it will be provided at this hearing, and that will include the I-213, which is, again, the arrest record of the client, kind of justifying why they're deportable, any criminal records that might be applicable, and also if your client was presented for asylum at the border, a credible fear interview, which is basically when an asylum officer met with your client at the border, determined that they at least had a prima facie credible fear of asylum to continue forward in their case. The reason that the 213 and the credible fear interview are really important is, like Jesse was talking about, credibility is absolutely critical in an asylum case. And even if it's not super relevant to the case, any inconsistencies can really be used against your client. So ICE is often looking for something that your client said on the 213 or something your client said during the CFI that does not add up with their testimony in their declaration or with their hearing or their testimony at the hearing. So it's important to get out ahead of that. And if there's something where your client says something's wrong on the CFI, or there's something that's not reconciled, like I was beaten up by 3 people or I was beaten up by 5 people, even though those things seem kind of inconsequential, it's important to catch them and be prepared to explain them so that your client isn't caught in a situation where their words are contradicting one another at different points, because that is, I think, one of ICE's key strategies in prosecuting these cases, is to look for those inconsistencies and attack on them. So be prepared and be on the lookout for that.
Another form that's often filed from the government is actually the border interview, and so that's another place to look for possible inconsistencies. That's usually only conducted with individuals who are entering without inspection and who are apprehended by CBP. And I've had a trial attorney base their entire cross-examination on an inconsistency between that border interview and the credible fear interview. So that's another place to look for any possible inconsistencies.
Okay, and then so after we get past the master stage, and this is probably where most cases will really begin for pro bonos, is the work that you need to do to prepare for the individual hearing, the merits hearing, the big day. So basically, there are 2 main things that you're going to prepare. One is going to be a pre-hearing statement, which is essentially the brief that you're going to write, laying out the case for your client and why your client should be granted asylum or whatever type of relief they're seeking. There should be a cover page, and then you'll get into an introduction, statement of facts, where you review the facts of your client's case, the personal things. You can talk about country conditions, and then making a legal argument to show that the facts that you're presenting are sufficient to reach the threshold of granting asylum or withholding of removal or cancellation of removal or whatever it is that you're seeking. And then it's also important that you include a certificate of service, because you're going to have to serve a copy of that on opposing counsel. The other document, which is, I don't know if I'd call it less work or more work than the pre-hearing statement. It's definitely less writing, but the evidence packet that you're going to submit, which is everything to substantiate the facts that you're going to make in your arguments. You're going to want to include, if you're going to have any witnesses testify, including your client, you're going to have a witness list right behind the cover page, and then an index of all of the documents. And your supporting documents are going to include a declaration of your client. So basically your client's written testimony that you've been hashing out through multiple visits. We have a bunch of redacted template declarations so that you can take a look and see what they look like and get an idea of what you're going to accomplish. Specifically, we have different declarations for different countries. So if you took a case for, a Nicaraguan citizen who had a political opinion claim, we could give you a template of another pro bono who worked on a similar case and kind of give you that to look at. And then to verify that, you want to try and corroborate it with country conditions documents, any amendments to other applications, like if the asylum application had an error in it or something that needed to be updated, you can amend that. If there are any family members or other people who can support other corroborating documents, try to get those. If there are any experts who are going to be providing affidavits or statements, include those as well. And then in terms of that, and just talking about preparing, I would add, and I made this presentation yesterday, so I should remember what I'm going to be talking about in it, but in case there's not a slide on this later, have an idea of how much time things will take. Like if you need a psych eval or you need a medical eval for your client or you need to get documents from Cameroon or Mongolia or wherever, you ask for them as soon as you know you're going to need them. Make those decisions early in the case because it can take a while. And, I think, WhatsApp and different things can be super helpful in helping you to get the documents quickly and efficiently sometimes, and it can work out really well. But sometimes you might get a declaration from your client's aunt that says something completely different, like that the persecution happened in September when your client says it happened in May or something like that, and you need to iron out and reconcile those differences because you can't turn in things with conflicting information. So it's a good idea to kind of prioritize the things that you need to get the ball rolling on quickly, even though they may not ultimately be that much work, but for you, but requesting and getting the clearance, finding a doctor who will come to the detention center, even though you're not going to have to write the doctor's evaluation, you want to ask for it sooner rather than later so that you're not getting laughed at when you call NWHHR and they're saying, yeah, well, we can go see you in 4 weeks and your hearing's, a week away. So you want to make sure that you jump on those things. And I will be pretty forthright with you when I'm talking to you. If I think a psych eval is really critical for your case, I'll tell you when you get on it. So we can kind of discuss those things and brainstorm them together. For some cases, it's probably not as critical, but especially if there's not a lot of corroborating evidence, it can really make or break a case in a lot of circumstances. And then motions are another thing that we need to talk about. So other than the initial filing that you're going to make at the hearing, you may have reasons to file a motion. If your client doesn't speak English or would prefer not to speak English during their hearing, you may file a motion for an interpreter. This may not be necessary if your client, so basically the language that your client specifies as their preferred language at the master calendar hearing, they will automatically be scheduled for an interpreter in that language at their final hearing. But there are certain times, like maybe a client who is pretty fluent in English ultimately decides that they'd rather testify in their native language at the hearing, and you want to change the language, file a motion for an interpreter. Your client speaks perfect English, but their mom's going to testify and she only speaks Spanish. File a motion for an interpreter so mom can testify. One other example I've had where a client had their hearing continued several times because the court couldn't find a Kirundi interpreter, but my client was also perfectly fluent in French, so we filed a motion to change from a Kirundi interpreter because the government wasn't really getting that filed. And just saying, well, fine, let's do it in French, but file a motion to get that done. If you have someone who wants to testify who can't be physically present in court, a family member, an expert, something like that, you can file a motion for telephonic testimony. By and large, if there's good cause, I think that the court's amenable to these. I think appearing as pro bono counsel and pointing out that the client's not paying their attorney anything and they can't afford to pay to bring an expert here, I think that that's generally considered good cause for the court, so that should be possible if your expert or family member can't make the trip. Motions to accept untimely filing, say you get that evidence 2 days before the hearing or something like that. If you're going to file anything after your deadline for a due date, that late filing needs to be accompanied by a motion to accept untimely filing. But again, as long as there's good cause, I would say that the court is pretty generous and reasonable on those motions. Motions for continuance, not very reasonable. Like you'd have to have a really good damn reason to get a continuance in immigration court, unfortunately. They are very much about keeping the gears grinding, so there'd have to be something very significant. I know Jason, who I think ducked out earlier, but who has previously taken a case, he had to get a continuance on a case because of a death in his family. Things happen, and I think the judges aren't incredibly unreasonable, but needing more time to prepare something like that is probably not going to be sufficient to get you a continuance. And then when you file your motion, you need a cover page. You need to include a proposed order at the back of the motion so the judge can either check the box granted or denied and send it back. And you need to have a certificate of service to serve opposing counsel. And then once you have filed all of your briefs and all of your motions, you need to get your client ready for the individual. So you need to figure out during the hearing, it's going to be a trial setting. Rarely will the judges ask for an opening statement. Basically, you'll review the evidence in the file, and then you'll go straight into direct examination. Have a game plan for what you want to do with direct. Practice the direct examination with your client, usually multiple times, but not so much that it feels rehearsed. And make sure that the questions you're going to ask your client, that you've asked your client that before. You know, it's not going to be the first time your client has heard that question, or you're going to ask a question and you have no idea what the hell they're going to say, because that's not fun. And then also identify, you know, what are the weaknesses or the potential issues in your client's case. Anticipate if you are being paid money to try and get this person deported, what would you want to ask? Like what will a prosecutor ask questions about on this case? If you feel stumped, if you're not sure, email me your declaration draft and I will write it back with a lot of, you know, kind of contradictory questions and kind of pretend to be a prosecutor for you and kind of point out what I think the flaws and weaknesses in the case are, so you have an idea and you can review that with your client. But again, like the hard questions that a prosecutor might ask your client should have been asked them already, and you should have an idea of how your client will answer them. And if your client has a hard time with a question or they get confused, prepare them for that. I think one of the really big things that we see is chronology and timelines. Like for a lot of people, like remembering dates and remembering the order in which things happen can be really tough, especially with trauma, PTSD. It's really, really a serious thing. So how can you best prepare your client to testify when they may not remember everything? And I think that, feel free to jump in if you have any ideas, but I think it's important to know what your client's going to get tripped up on. And if it's dates or something like that, don't go too far on them, and have your client be really honest. If he or she does not remember a date when something happened or the order, it's okay to not know the answer. You know, you don't, like, I think sometimes there's a pressure to say, oh, that happened in March, when you're not entirely sure, but you're pretty sure it happened before the other thing happened, and you know that other thing happened in September and it was a few months before that, or something. Like whatever you know your client will be able to consistently answer over and over again. Try and frame those facts that way. And also, I like to get ahead of it. If there's something where your client gets confused sometimes, get ahead of it on direct when your client can anticipate the questions that are coming because you've practiced them before. Don't save it for the government to bring up in cross-examination when your client's going to be extra nervous. Try to create a controlled environment where you can present the facts in a coherent way. Do you have anything you want to add, or?
Your client does speak a second or different language than English, it is important to practice the interpretation portion of the testimony. So essentially, coaching them on speaking in 2 to 3 sentence phrases rather than an entire paragraph, because it won't be interpreted. And also preparing them for the situation where they might be interrupted and then have to restart. And so that just, it's good that they know what to expect in that situation. Also with clients that speak English, or at least some English, having them really listen to the question in their native language rather than in English, and trying to answer in English. The court gets pretty angry when folks try to use a language that they're not supposed to be testifying in. And so that's, yeah.
No, both really good points. And yeah, I think the other thing just off of that is with witnesses that you might be calling who will be testifying in different languages and who you might have less time to prepare with, if you're going to have an expert or a family member testify, try to at least practice testimony with them once or twice and have an idea of how they'll handle things too. It can be tricky because you're so focused on your client that you lose sight of other people who might testify. But if you do have multiple witnesses, make sure that you're preparing them as well. And I think also it's a good point that I would say that at least with two of the judges in our court, but especially Judge Odell, likes to interrupt. Like if he thinks of a question, he's just going to blurt it out and ask it. And you should get your client prepared to have like your line of questioning kind of cut off, and you might get pulled in a different direction. And just to be ready for that, because obviously, like there aren't that many times in my life that I've been around people who are as nervous and on edge as people who are going through their individual hearing, because it's the biggest day of their lives in a lot of ways. And literally for some folks, it's their life on the line. So anticipate your client being very nervous on the day of the hearing, and try your best to hedge against that. And also just, it's one of the reasons why building trust with your client is so important, because if your client knows that you're on their side and you're in their corner, they'll feel comfortable having you there, and you can kind of be like a calming force for them. And then Jesse's point, practice questions with interpreters. And then I also think it's always a good idea to draft a closing argument. You may be prompted to give a closing. Sometimes I've been asked if I want to make a closing statement. Other times the judge is just like, yeah, well, I'm going to grant, or you're not sure. But if it's good to have something prepared and know what you want to say, basically to reiterate the framework of your argument and your pre-hearing statement. Not just say like, Your Honor, he's a really great guy, cut him some slack, but like really point out like where in the law the substance of your argument is coming from, that this was past persecution, or that was not firm resettlement, and this is why. Citing, basically cite cases in your statement, point out the legal justification for why you are making this argument. I think it's good to have that prepared. I would say that probably less than half of the time I actually give a closing statement. But if I'm prompted, I will do it, and sometimes I'll ask permission if I feel like the hearing is going poorly or there's something that didn't get said. I'll want to really steer back to it. So it's a good idea to be prepared and think about what you're going to say in a closing.
When I prepare for closing arguments, I generally don't prepare just one. I'll actually prepare just a list of different arguments for different issues, and actually ask the court just on the close of testimony what issues the court sees as being sort of problematic, so I can have an idea of how to address it. And that's been pretty successful, particularly with Immigration Judge Floyd. He really doesn't like pre-prepared statements. He likes you to argue what the issues are rather than just arguing the entire case. So that's one tip that I would say has worked out pretty well.
I basically will take the outline from my pre-hearing statement and just turn it into bullet points, but making sure that I remember that, oh yeah, the case that I was citing in my brief about firm resettlement is Campos Castañeda, so that I have the site in there. And if I feel like the judge is going to grant or deny the case based on the firm resettlement issue, I'll go to that part. If that seems like it's not an issue to the judge, I won't bother, and I'll just talk about, the well-founded fear or whatever other thing, that there was past persecution. But for me personally, I rarely write something out verbatim. I just kind of make a sketch of an outline of the things I want to cover and the relevant case law. But moving forward past the closing, the other thing that I think is super critical to prepare your client on, if a hearing goes poorly, like if you win, it's great, like everyone's happy, but you need to be ready if the hearing goes badly and you're denied. It's a really hard thing for a client to be ordered deported, and they may not be in a very good headspace to decide if they want to appeal or not right after the hearing, because it's a traumatic thing to be told by someone else that they're going to deport you. So I think it's really good to talk to your client ahead of time about the possibility of losing their case and whether or not they want to appeal, because you'll have to tell the judge right then and there if you're reserving the right to appeal or waiving the right. If you waive the right to appeal, the order of the judge that day is final, and they will try to put you on the next possible flight they can to get you out as soon as they get travel documents and everything else arranged. If you want to reserve appeal, you have 30 days to make up your mind if you want to mail in a notice of appeal or not. So I tend to advise my clients that the best practice is to reserve the right to appeal, take a day or two to sleep on it, figure out what they want to do once they've cleared their head, spoken to their family, if they feel like they can handle being in the detention center for another 6 to 8 months while the appeal is pending. And if their decision is that they want to go for it, then you'll have to make the decision if you want to continue representing your client on that appeal, or if you want to kick it back to NWIRP to see if we can place someone else or help the person pro se, or however that would go. But that's something that we can discuss after the hearing, that when you go to follow up with your client after they think about it for a few days, hopefully you'll know whether you can say, look, I want to fight this appeal, I will represent you on this, or if you decide to do this, you're going to be on your own, but I will ask NWIRP if they can help find another attorney to represent you, or they will help you to write your brief on your own. It's a tough conversation, it's not fun, but I think it's important for your client to have a very realistic expectation of what could happen in that case, because otherwise it's a whole lot of information that they're going to have to think about in a very, very difficult headspace. The other thing, your client might win, and if that's the case, where are they going to go, and who do they know in the area? Is someone going to be able to pick them up or take them to the airport? There is a group that several of our guests today have volunteered with called Aid Northwest that offers a lot of really great post-release services for clients. We will make sure that you are in touch with that organization and have their email address so that you can reach out with them if your client is granted relief, that they will have someone that they can access if their family isn't nearby or able to pick them up from the detention center. Any questions about the actual hearing or any of this before we keep going? Okay, so we've talked a little bit about appeals, but basically if you lose a case and you have to file an appeal, you're looking at 3 to 6 months in detention. Once you have reserved the right to appeal, you have to file a notice of appeal, which is like a 4-page form. It's pretty short, and you just basically lay out what the framework of the issues you want to appeal are, and you have to file that within 30 days. After that, you will get a briefing schedule from the BIA as well as a printed transcript of the entire hearing. And from the date that you get that, you'll have 21 days to file a brief. You can file an extension you can file one extension of that, so you can extend your 3 weeks to file the brief, an additional 3 weeks to have, 42 days total. And then after it's filed, generally, would you say we're seeing decisions come back in about 3 months from when you file? 2 to 3 months, yeah. So after you file the brief, depending on if you get an extension or not, 2 to 3 months after that, you'll get a decision. If your client loses at the BIA, it would go to a circuit court so that your client could conceivably appeal to the Ninth Circuit, and you're looking at least 2 years of a process there. It would begin by filing a document called a petition for review. You would also file a motion for stay, and then you would have to file an opening and response briefs, oral arguments, possibly. But this is very unlikely to come up in the pro bono context, just to give you a sense. If you win at the appeal level at the BIA, then the case would be remanded back to the immigration court, or the decision of the judge would be reversed outright. So more often than not, the BIA's decision will be to remand, and then you'll have another hearing in front of the immigration judge, as opposed to them reversing the judge's decision and granting your client relief that day. So just to set your client's expectations, but again, this isn't a CLE on appeals, so we won't go too far into it. But hopefully your client wins and they get out of detention. If you have a hearing, and most of the individual hearings take place in the afternoon, 1 o'clock or 2:30. And then once the hearing is over, the TA, or the Office of Chief Counsel Attorney, who's the prosecutor, will be responsible for notifying your client's deportation officer of the decision, and then they will begin the process of releasing your client. The deportation officers go home usually around 4 or 4:30, so if you have a late hearing and it's getting out, like later in the day, there's a chance that they won't connect and your client may not get released until the next day. So what I like to do, especially if I have a G28 on file, is get a copy of the order and just run it upstairs at the detention center to the deportation officer and just knock on the window and be like, look, this guy won, get him out today, get him out today, get him out today. And usually that works, just be the squeaky wheel a little bit. Of course, the government can reserve appeal, so there is the chance that won't work out. When your client's released, they'll need to have an address to give to ICE. So if they don't have a place where they know they're going to go, you're going to want to give them an address. Contact Aid Northwest potentially, and they can help with an address for where they'll stay temporarily, or figure out another solution with your client, because they'll need to come up with their plan. Release usually happens between 4 to 6 p.m., and I'm curious if the folks who volunteer with Aid Northwest, do you see people getting out after 6 often?
Anybody
Occasionally.
here at the RV? Sometimes I read the reports and sometimes it can be as early as 2 or 3.
Oh, really? I haven't seen that often, but okay. Good to know, good to know. And then, yeah, so Aid Northwest, there's an RV that's parked outside of the detention center on all days where there's hearings. And they will be there during this entire window of time. And they can help with giving your client a warm place to stay. If your client was picked up on the southern border and has, never seen a, snowflake in their life, and then they come in a blizzard in February or something like that, they aren't prepared for that weather. There's a lot of donated clothes, especially warm clothing, that's available through Aid Northwest. Cell phone chargers, things that people need right when they get out, so they can kind of try to make those arrangements. And they're really fantastic and phenomenal, and we very much appreciate them with the work that we do. So we, thank you to those of you who are still here, and I know there were a lot of you here earlier. But a phenomenally good resource for you if your client does get released from detention and is successful in their case. And we'll go over really quick just kind of what the responsibilities and expectations are, and this is pretty brief, and then we'll just open it up for questions, comments, conversation. But basically, you need to assume all of the responsibilities as a pro bono attorney that you would if this was your own paid client. You have to zealously advocate for your client, make sure that you're filing things timely, be at all hearings, and make sure that you're in full compliance with the rules of professional conduct. If you have any questions about that, let me know. I'm happy to discuss with you what we're talking about. And then you need to make sure that, and this is a judgment thing, but make sure you're meeting with your client as many times as is necessary that you feel that you're going to be able to adequately represent them in court. The day that you go into court, you should know your client's story as well as they do, if you can. Be sure to timely prepare and submit all filings and motions. Again, if there's some reason you can't file something timely, like you get it the day after your filing was due, there are avenues for that. There's no need to panic, but try your best to be timely in those things. And then the other thing that's important that I think sometimes can be challenging to keep in mind, clients should get a copy of everything that you submit. This is just like anyone who pays for your services as an attorney. They have a right to know what you're doing. For me personally, I like, as I go, when I file something, I bring a copy to my client that same day or the next time that I visit them so that they know exactly what I've been up to and what's happened in their case. And they can basically have their own copy of the file in their pod. There have been times where you need to be thoughtful about this. I've had clients who don't want copies of anything. Perhaps, like for the example I can think of was a client who, identified as gay, but was not openly out in his pod and didn't want people to know that about him. And he was afraid that if he left paperwork lying around, someone would find out and that he'd be uncomfortable with that. So he asked me to keep all of the copies of his documents, and then I gave it to him at the end after we won his case. So it kind of goes by feel a little bit, but make sure that you're being accountable and respectful for your client, because it's an important part of building the trust that's really, really essential in these cases. Again, as you're working and trying to keep your deadlines, hearing dates, and decisions and all that stuff straight for yourself, make sure your client's apprised and make sure that they know what you're doing when you're trying to do it. Often, when I'm busy the week that a brief is due and I'm going to be writing and I'm at the office and I'm not going to be visiting very much because I have all of the paper stuff to do, I'll warn my client, like, look, your brief is going to be due on Friday. I'm going to be working on it all this week. I might not come see you at all, but I will come see you Friday afternoon to give you a copy of the brief, and trust me that I'm working on it. Just to communicate that and make sure that they can expect what you're doing and they know what to expect from your end. Because I think really people are on an island at the detention center, and it's really helpful for them to know what you're about. Let me back up there. Sorry about that. So yeah, again, like I've been saying, like treat your client with professionalism. Confidentiality is a super important thing. I think it's tricky because you do volunteer work. For a lot of people, it's good publicity for their law firm. You're taking these pro bono cases, and immigration's kind of a hot button thing right now, and it's sexy and all that. So you want to point out what you're doing. And that's fine, but you need to keep your client's confidentiality in mind. So if there's ever a point where you want to advertise or talk about your pro bono work, you want to make sure you're talking to us about how to do that, and also getting your client's consent that you can share this information, because that's really important. But also it's good to share that you're doing this work and raise awareness. So we're supportive of that. It's not anything that's an issue, but just be mindful of the fact that your client is sharing some of their, deepest fears and insecurities with you as they're going through this case. So you want to be mindful of that. And then again, if there is an adverse decision, make sure your client understands what the appeal process looks like. You want your client to be able to make informed decisions about anything relating to their case. If there's ever a point where you need to withdraw from representation, as you've signed the attorney acknowledgement agreement, one of the things that we say is that it will be your responsibility to find other counsel for your client if you need to withdraw. If there is an issue with representation, please let me know as quickly as possible so we can brainstorm it. I think that we definitely don't want this to be like a hardline thing where it's like, Paula, if you can't take this case anymore, you need to hire an attorney to represent your client, because that's not going to stand. Like we'll work with you, see if there's something that can be figured out. We want your client to get good representation, but also it's something where you need to understand that you are responsible for this case. I am going to trust that you're working on it unless I know otherwise, and we don't want people to be left hanging. It's really difficult if that does happen. The other thing that's important, let us know ASAP when your case is done what happens, because it's helpful for us to know, especially if the client gets denied. If your client loses and you don't think you can take the appeal, we want to make sure we're going in to meet with your client and helping them so that we can figure out in a timely fashion what their next steps and options are. It's also helpful if you can report back any issues that come up in a case, not only so that we know for a denial, but even in the event that a case is granted, like Matt had a case granted last week, right? Last week, yeah. But it was one of the first cases that we've seen where the client was held under the new asylum ban. And it was helpful for me to hear how Judge Floyd talked about it during that hearing. And it's good intelligence for me to have to offer to other pro bonos who are going to have similar issues coming up. I learn a lot of gossip from you guys that I will then share with other attorneys to help kind of grow our knowledge base. And then I will also send you a closing memo, and we need this for our, first of all, it helps me to figure out what I can be doing better to help other attorneys, but then the other thing is data like the hours volunteers spend. It's important for our funders. It helps NWIRP to get money to keep doing this. So completing that closing memo is really helpful, and we encourage you to do that whenever you can. I think this is another important thing to talk about. I'm just gonna, I don't like it when it comes up one at a time like that. But anyways, there's a lot of limitations that people deal with in detention. Lack of access, lack of resources. It's dehumanizing and hard. And the client, there's power dynamics there where you're the person who can walk in and out of the jail and they're not. So your client might be inclined to view you as the boss or feel like there's some obligation that they have to you that they really don't because you're the person who's doing this for free, you're volunteering. And it's important, I think, to reiterate to the client that your duty is to empower them and help them to do what's best for them, to act in their interest and be their advocate. And it seems kind of basic to say this, but I think it's just important because I think clients really do a lot of the time defer and are nervous about kind of feeling ownership of their case. And it's something that's really great in representing people to make them believe in themselves and trust you. And I think through that process of gaining that, like, not only is it just a nice thing to do that's appropriate, but it also helps your client testify better. I really think that if your client trusts you and you have a good relationship with your client will do better on direct when you're the one asking them the questions. So I think it's really important to try and build trust and understand that, I guess your client has no good reason to trust you because probably every other white person they've ever met has screwed them over in some kind of way. So, not that everybody in this room is white and not that, it varies a bit, but like there's a lack of, like there's no reason to assume that your client is going to trust you right off the bat. And your client might not feel comfortable sharing all of the details of their case right at the first sit down. Like once they build a rapport with you and they trust you, more things will come out. And I think, as we break into questions, Paula can probably share some more about that because you've really gotten some clients to open up in a really, really big way. And then other tips, like we talked about before, don't go during count because it sucks. The best times to visit are the evenings, weekends, and early mornings. Good idea to plan for delays. And then in terms of interpreters, like we've talked about, NWIRP will work to help you find an interpreter if you need one. We'll chat about that when you take a case. And try to be efficient with your client's time, mainly for your sake. Have a plan. Don't do what I do and print something out to take for your client to sign and then leave it on the tray of the copier and go to the detention center. Make sure that you're prepared, you're ready, and you know what you're going to try and do during the meeting. Have that structure, be willing to be flexible with it and realize that your client might go off the rails, your client might break down in tears, and you might have to end early or take a break. But really just try to be mindful that you want to be as efficient as you can with the time you're in the detention center, but be flexible and supportive of your client and be willing to work with them. And then recruit support. Get people on board for your case. Find family members, experts, people who can help you brainstorm issues. The more people you have involved in your case, the better. I would really point you to check out the Center for Gender and Refugee Studies at the University of California, Hastings. They have a great database of expert affidavits that are generalized, and they also have contact information for experts on a lot of different issues for different types of cases. And then again, it's a good idea to figure out if your client would benefit from a medical or psychological evaluation, but we've been talking about that, so I won't go too far in. I think, there's a couple of those old school adages that still make a lot of sense with this, like be nice to people, be nice to ICE even if you think they're evil, be nice to the judges and be professional and courteous. But also there's a lot of court corruption in different cultures in the world, so be mindful that if you're being all chummy with the opposing counsel, your client might be uneasy that the court is kind of a rigged deal. So it's good to like let your client know that the reason you're going to try and be very friendly and respectful to everybody is just because you're trying to be professional and you don't want to get people mad at your client because of your conduct. I think it's good to get out in front of that. And also, you know, like be persistent, make sure that you're staying on top of things. GAO guards and deportation officers are not the most responsible people in the world, so they may not respond to you right away. They might not call your client down right away. Try your best to stay on top of things, but again, in a polite and respectful manner. If you need to observe a hearing at any point to prepare yourself, I think it's a great thing to do. You can prepare for a hearing really well. Master calendar hearings, if you want to watch one, they're always open hearings in the mornings. Just go down to the detention center and watch. If you want, they take place Mondays through Thursdays, usually begin around 8:30 in the morning. If you want to observe an individual hearing, let me know, and I will try and set that up. Again, Matt had that hearing last week, and an attorney came and observed that hearing to kind of get an idea, and I think it can be really educational, especially to watch another pro bono in action and get an idea of how that works. If you want to do that, contact me, and I'm more than happy to set you up to observe a hearing with somebody and work with your schedule. And then technical support, again, I don't know, I need to get better at PowerPoints apparently. But yeah, so my whole job is to make your job easier taking pro bono cases. That's my contact information. Let me know if you ever want to email me with a question, set up an appointment to talk on phone or call in person. I'm more than happy to sit down, chat with you, look at your documents. I have plenty of templates and samples that I can share. And I'm happy to offer feedback on your writing, help guide you with a pre-hearing statement or a client declaration, or just kind of brainstorm how ICE might view different arguments you would make. So if you want feedback, generally I'd ask you to try and give it to me at least 5 days before you would need it, just to give me a little bit of time to get it. But otherwise, I'm more than happy to help and support you in any way going forward on a case. And then I would also just kind of end with this point. Remember that, you know, asylum seekers have almost always suffered some significant trauma. And it's important to be patient and use empathy when you're dealing with your clients. Some of them are really difficult to work with or very stubborn and insistent that this is the way things need to be done. Others are very deferential or just very nervous to talk about anything. And I think it's important to, you know, take breaks when your client needs them. Don't try to do the whole case at once. And again, building trust with your client. I think it's like, for me, it's like virtue number one in these cases. And be mindful of secondary trauma. You know, you're going to absorb some of this stuff hearing these stories from your client, and take care of yourself and be aware of how you are processing and dealing with that information that you're receiving as well. Yeah, and that is all we have for a presentation, but if anyone has any questions, if Matt or Paula especially, or Joanne or McKenna, if any of you have anything you want to share from your experiences, please feel free to take the floor. It can just be kind of open. So.
Do you sign Franco's? Do you sign the people from Franco?
No, so Franco, so the Franco class is people who are found to be mentally not competent to stand trial on their own, so people who have some significant mental illness generally are appointed counsel. And the contract for the Franco counsel is not through NWIRP, it's with different private attorneys. There's a couple of different law firms that take those cases. We know those attorneys very well, but we are not associated with that, and pro bono counsel wouldn't be either. But if there is a point where you take a pro bono case and you're concerned that your client may have a serious competency issue, let us know and we can talk about how to address that. Matt or Paula, do you have any advice you'd share to potential attorneys?
Just to, if you can, visit as much as possible. I visit my clients twice a week, and I'm getting information from them for preparation of my paperwork that I'm going to file with the court. And also, I spend a lot of time working with them on their testimony, preparing them for my direct questioning of them. And I also do some role play, acting like the trial attorney and cross-examining them and beating them up, basically, so they get used to nasty questions, mean questions, and how to handle it. And above all, to get them to tell the truth, no matter how much they don't like the information. So that's it.
Mm-hmm. Great.
Yeah, I would say that the trust is a big one, and that's something that I found with the most recent case, and building trust was difficult. Part of that was he couldn't understand why I was doing it for free, and the answer, because it's the right thing to do, didn't quite compute. And so it took him a while to understand that. And he did also admit there's this feeling that if you're a volunteer attorney, you're not as good. So just be aware of that. I think you just prove that you are good by showing up and working hard on their case. One thing with the like nervousness the day of trial, I think it's important to let them know that they're going to be nervous, and more likely than not, they're going to make a mistake on direct, and to not panic and try and fix that themselves, and just let them know, like, if you say the wrong date, let the attorney, kind of fix it rather than to seize up and realize you made a mistake and then kind of panic. Just say, look, you're going to be nervous, you're going to make mistakes, that's my responsibility to correct that, let me handle it, and not worry about that.
And that's actually a really good point, something that I don't think we talked about at all, is I think when you're preparing your client for direct, it's good to make sure you practice answering the question that's asked. I think there's definitely a tendency, like for a lot of people when they're nervous, to go 3 or 4 paragraphs, and just kind of go down some rabbit hole that's nowhere near what was asked, and then everything can fall off the rails, especially if someone makes a little mistake and then tries to over-explain it. A colleague of ours was telling me that the other day she was prepping a client who was doing this and basically stopped and then asked the client after one of those long diatribes, "What was the question I just asked you?" And he got the point that, like if you can't remember the question that you were just asked, you weren't answering the question. But I think it's especially important with cross-exam because that's going to be the most nerve-wracking part for a detainee. And it's going to be, they're also trying to get you tangled and twisted up with your facts. So it's very easy to get mixed up and to over-explain things. So I think practicing with your client to keep their answers concise and to the point, because you can always ask more questions. It's not like the judge will say you can ask 5 questions and 5 questions only. Like you have the right to ask as many questions as you need to build the case. So brief, to the point answers, like 2 or 3 sentences, helpful for an interpreter, but also just helpful for keeping it concise, and then you can ask follow-ups. So good point.
That they understand that if they do not understand the question or do not understand the interpreter, that they should not answer the question, because that does happen quite a lot, especially when you have an eager client who's just wants to get their story out. They will oftentimes just be like, okay, well, that was kind of like this, but I didn't totally understand it, so I'm just going to give an answer. And that's when you start going down those rabbit holes or word vomit. And just, making sure that they're listening to the question and they completely understand it before they do. And I tell them, a pause is not a bad thing. Like if you need to pause and think about it for a second to just absorb that question, no one is going to fault you for it. And it's going, taking that one breath is going to save you so much time on the back end trying to correct that mistake.
Absolutely, yeah. Now I know we're kind of at time, but does anyone have any other questions or anything else that they'd like to add? Joanne or McKenna, do you have any experience you'd like to share from your work?
I was an assistant, so it was really cool to go through the process, and I knew basically nothing, and I didn't have 0 legal background or anything, so I thought it was just cool, and I think, I don't know, it's speak for you, but it was fun to kind of do it in tandem and like work off of each other, and like having an attorney kind of mentor me was very cool. So very fortunate.
And with having just worked on your first case, was there anything that was surprising or challenging that you didn't anticipate?
I think I had heard, so when Matt did his first case, kind of heard, because both of them are Southern Cameroonians, and it was interesting to see kind of how they overlapped, but also just the difference in the clients. Or I never met, Nestor was the first client, but I never met him, and it was interesting just to see kind of how they differed, and like Matt saying, it was difficult to kind of build trust and to be like, we're working really hard and we're not going to let you down. And even with like sharing documents was interesting. Like he didn't want us to take any of the documents to scan ourselves. He would want to do that and then give it to us. But it was cool to see kind of how that trust evolved over time. And like at the end of it, I felt like very close to him, which was really cool.
Good. Nice.
I think one thing that I forgot to add about the trust is like, talk about stuff that doesn't have to do with the case. I think just general small talk, find out about them as a person aside from, because like you spend most of your time talking about all these horrific things that have happened to them, but if you talk about just, you know, the better parts of their life, I think you get to know them a lot better on a deeper level, and that helps build that trust.
Mm-hmm. No, that's a great idea. Perfect. Well, thank you all so much. I know those of you who are still here, I know a bunch of people have left, but there are some review forms if you want to give us any feedback on the CLE. It's totally optional, but if you would like to fill out an evaluation and just leave it on the table, we'd appreciate it. And otherwise, thank you so much for coming. Oh, sir.
Is the bar giving us credit?
Yes, so if you signed in on the sheet out front and you wrote your bar number down on it, then we will report it to the bar and make sure you get credit. If for some reason it's not reflected or you have any questions, feel free to contact me.
Will we get an email of the PowerPoint?
Yes, so if you signed in with your email address out there, we will send out all of the slides. I'm going to try and do it all tomorrow, so you should expect it then. Yeah, yes, sir. Perfect. Thank you all so much.